Hello, everybody, and welcome to another Smart Home Choice podcast. As always, my name is Gary Hibbert, and this is episode 32. Now, of all the years that I've been doing the podcast, I've never actually said an episode, and I kind of went back and I started taking a look at how many podcasts I've done. And I usually do them once a month, but I've never actually said the episode, so it's kind of weird saying that. But I think going forward, I'm going to start telling you what episode I'm on. And the way that I see things going as well too is that I definitely want to start doing more of these. I'm really enjoying the podcast and the way that I see the business going. I should hopefully have more time doing this because I do enjoy it, and I enjoy bringing new content and great guests on the show. So definitely keep an eye out for that. But on this podcast, I got a chance to sit down with Howard, and I'm looking at his last name right now in front of me, and I'm not even gonna try and pronounce it. Okay, so you'll see it in the notes below. But Howard's a paralegal, and this was a bit of a longer interview compared to the other ones that I've done. But there was so much information and so much content that I didn't want to stop him because he's just full of so much information. And when somebody's pouring their heart out and sharing all their information that they've got on a particular topic that they're passionate about and that they love, I gotta let him go. I can't stop him. It's difficult, right? So sit back, relax, and really enjoy what Howard's got to talk about in this podcast. Some of it is scary. I'm not gonna lie, but I think at the end of the day, what Howard is really saying, and I've always said this as well too, is make sure that you surround yourself with the right people. Make sure that you educate yourself when you're getting into the world of real estate investing. Because I could sit here and paint this rosy, beautiful picture for you, but it's not always the case. That is, I think, something that I try to get across to anybody that's ever talked to me. It's not. There are pitfalls, there are issues, there's things that you do have to be aware of. And I'll end it with this, saying that if this was easy, everybody would be doing this. And it's not. It's far from it. So I hope you guys really get some good information out of this. I know that I did. Again, anytime I sit down, listen, and do these podcasts, I always learn something new. So that's really why I enjoy doing this. So take care, and I will talk to you guys next month. All right. So on the call today, we've got Howard Tavroges, and I hope I got your last name right.
You perfect. Absolutely.
Beautiful. I was practicing that there for a little bit. But listen, thank you very much for being on the call today. And listen, I know you've come out to our mastermind events. You did one actually earlier this year. And, we can't always get everybody out into the room. And sometimes people can't make it because of their busy schedules and what they've got going on in their lives. But I really wanted to have you on the call because what you talked about that day was good. Maybe a little scary for some people, but I like to put some of that scary stuff in there as well too, because I want people to be prepared. But I guess before we get into everything, if you don't mind, maybe just giving the listeners a bit of a background of who you are, your experience in life and why you kind of chose this career.
Sure. So to give you kind of what they call the Coles Notes version, I'm originally from Toronto. I was born in Toronto. I happen to live in Barrie now, but that's just where I live. And I went to school in Toronto, but I went to university actually in New York City. I was in the fashion industry for the first half of life, basically 20 odd years. I lived in the Orient for a few years. I actually run a couple of companies in manufacturing arms, etc. here. And my claim to fame, and this is what I don't know if I've mentioned to you before, but I lived in the dormitories in New York, in Manhattan. Actually, I went to the Fashion Institute of Technology in New York. And my claim to fame is the fact that in the dorms, and I didn't know this until years later, after I graduated from a friend that I went to school with, across the hall from me was Michael Kors. So, and obviously I wouldn't know that at the time, but it's kind of like, my, like I said, claim to fame in regards to that. But in regards to the legal stuff, so after I was in the clothing industry for a long time, and it's not that I got bored. I loved what I did, but it was just I thought it was time for a change. So my wife and I sat down and like, what are you going to do when you grow up? And I said, well, I'd like to go into law. I was in the clothing industry. Now I'd like to go into law. So I did a little bit of investigation. I have some friends that are lawyers, and they said, the makeup of the law class now is totally different than it was before. But, the first step was you have to write your LSATs, the law school aptitude test. So I figured, you know what, set up to fail. I think I'll do great at it. I wrote it. I did really well. I applied to law school. And before I actually went there, I said, you know what, I want to make sure this is what I want to do, because it's not like I'm 20. And if I'm going to spend all this money on law school, I want to make sure this is the career I want to go into. So I said, well, I'll volunteer. Well, easier said than done. I tried to volunteer at a whole bunch of law offices in Barrie, in Toronto, etc., and nobody was taking volunteers. I'm like, really? Do you understand what volunteering is? It's free. And, I got into some, I'm not going to say arguments, but kind of discussions with human resource people in a number of law firms. And I got frustrated. So just as luck would have it, I met a gentleman who worked at a legal clinic in Orillia, which is just, as everybody knows, is just north of Barrie. Mm-hmm. And I asked, did they take volunteers? And he said, yeah. And I went up there, and they took me on, and I started volunteering once a week. And this was around 2006. And they liked me, I guess, because they hired me. And the job that they hired me for, which I think, as I always say, everything is for a reason, they hired me to do tenant duty counsel. Well, tenant duty counsel is at the Landlord and Tenant Board, and you represent tenants. And with the legal clinic that I work for, it's legal aid. So the clients that I had obviously didn't have money, and it was either like low income or they're on social assistance, etc. And not only did I do the tenant duty counsel, but I also did ODSP hearings, Ontario Works hearings, because I wanted to kind of broaden my horizons, know a lot about the other areas of law that related to landlord tenant. But in the time that I was tenant duty counsel, which actually stretched over 5 years, between 2008 and 2013, I only know this because it's legal aid, and everything's statistics, I represented over 15,000 tenants. Now that's a lot of tenants, but it's benefited me now because I left the legal clinic in almost 4 years ago. It was November of 2013 to go into private practice. And I said, as I left the dark side, representing tenants, and it's not really the dark side because they need representation too, but right. I only represent landlords. And that's what I do 24/7. Literally, I do it 24/7. I'm very accessible, Monday to Friday and on the weekends because, as landlords know, I mean, problems don't happen Monday to Friday, 9 to 5. It's always, 11 o'clock at night, or God forbid, 2, 3 o'clock in the morning, or it's on the weekends, etc. So I'm accessible when anybody would have a question, or when they have a question, because, they need me. It's not like, oh my God, how do I deal with this? Oh, I can't speak to Howard until, Monday at 9 o'clock. So that's what, I'm not going to say makes me unique, but I'm, like I said, and I'm always ready to answer any questions or concerns that people have, and that's just the way I am. And so why did I choose this? I think actually the career chose me. I mean, if you want to put it that way, because like I said, when I started the legal clinic, I had no idea that I would go in this direction, but I was blessed for the fact that I got that position. I loved what I did at that point, and I really, really, really love what I do now. And right. I give it like 10,000%. So,
and that's amazing.
And that's not really it's not really a Coles Notes version. It's like a longer form of a Coles Notes version, but that's where I am as of today.
Well, when I usually hear like a nice long intro like that, and really kind of giving your background and talking about what you do today, I can tell the passion, and it definitely sounds like you enjoy what you're doing, and especially the fact that you take calls on the weekends as well too, because as a landlord, especially if you're new to it as well too, it can be scary. And it definitely sounds like you're well versed in it, and I think it's great that you've also done the tenant side of things as well too. So I'm sure you've probably seen the nasty side of how terrible things can actually really get.
Well, actually, what I call it, I mean, I call it, this is just my analogy, the 90-10 rule. 90% of tenants are amazing, 10% aren't. And it's the same thing that works with landlords. 90% of landlords are great, and 10% of landlords are bad landlords or slumlords, etc. But, thank God it's that percentage. It's not like, 50-50. It's like a high percentage, not to scare any landlords or potential landlords off. It's great. I mean, and it could be very profitable and fun, but it's challenging, I'm sure, at times for a lot of them, which I see obviously in my work every day. But you kind of work through everything.
Right. Now, for our listeners, I've got a number of different listeners out there where some are advanced and some are just getting into this. Let's say now if you want to, screen your own tenants, and you're doing this for the first time, or maybe the second time, what can I legally ask to see from my tenant before they move in? And what can't I ask for, like as a guideline?
Okay, so that's a really good question. So what's a really important thing now, and I'm sure everybody's aware of human rights. Human rights is huge. You got to be, as they say, walking on eggshells, because you got to be really careful. Exactly what the question is, what you can ask and what you can't ask. Well, what can you ask? You can ask about their income, obviously. So, I mean, if they're, I work at GM, or I work at Honda, or I work at Tim Hortons, or wherever they work, how long have they worked there? Do you work full-time, part-time? How many people are going to be living in the home? I mean, and again, are they all tenants? Not really. I mean, because if it's 2 adults and 3 children, the children are not considered tenants. They're considered occupants. Do they have pets? Does that mean they can restrict pets? No, because that's changed as of 2006. But a lot of landlords will ask that ahead of the game, or ahead of the tenancy. And it doesn't mean after the screening process goes through, they become tenants and they bring in a pet, that you can kick them out, because you can't. But it's good to know ahead of time. Do they smoke? Because again, depending on the size of the rental unit, it could be non-smoking, and most places are non-smoking. I'm a non-smoker. I don't like smoking in the least, and I don't like the smell of cigarettes, but that's me. But that's a personal taste. So, but you can't make something non-smoking where the parties are already smoking there already. But again, you can ask these questions. You can ask for a credit check, or permission to get a credit check. And some tenants who do not want to provide like a social insurance number, and they don't have to under law, they say, you know what, is there a way that I can get a current one from Equifax and just give it to you? And that's okay too. A kind of a yes and no one that a lot of people ask me is in regards to criminal checks. Can you ask for a criminal check? It's a yes, you should ask, or could ask. Can you get in trouble for it? Maybe, because again, it's a human rights. I mean, if somebody's been incarcerated and, they're just, life's threw them a bad curve at some point, and, they turn their life around and everything's going better. Some landlords will be like, oh, well, this guy was in jail. Don't even know what they were in jail for, and it may stop them from getting a place to live. But everybody has a right for a place to live. But it's one of those questions that's kind of borderline. I mean, let me back up a bit. But I always say the best way to look at it is a gut feeling. So if you're meeting somebody in person, and you should always meet somebody in person, I don't think you should do everything over the telephone. I mean, initial interview, yeah, but it's always really important. I mean, if this person is living in your home, and a lot of landlords have people living in the basement of their house, or, a 3-story building, or, apartment complex, etc., you should always meet them face to face, no matter what. And if they say they can't meet you, that should be like the first sign right there that something's not right. So that's really important.
Right. And I think you hit on something really good there as well too, is the gut check. The gut check is
Yeah.
such an important check because
Yeah.
my gut's never been wrong. And I think for the most part,
Yeah.
most people as well too, right? So
Yeah.
I just
Yeah.
wanted to kind of jump in there and say that. So it's a
No,
good
but
point.
it's true. It's true. And like they always say, go with your first intuition. Go with that one first. Don't kind of second guess yourself. And it's not, and it's just don't judge people necessarily the way they're dressed. I mean, because some people dress differently than other people. I mean, some people, again, and that goes back to some of the questions you can't ask. You can't ask them, their ethnic background. You can't ask them if they've been married, single, divorced. You can't ask them in regards to their sexual preference. You can't ask them, if they're on social assistance. I mean, you'll find out quick enough because, again, landlords that are out there, that somebody who's on Ontario Works or ODSP, a lot of times, and people rent out to people, which is great. I mean, that doesn't make them a bad person, but they'll get what they call an intent to rent form from ODSP or OW that you have to fill out. So you're going to know right away that that's where they're getting their money from. One thing I always suggest, I mean, if you're not really sure, check out Human Rights Ontario, like the Ontario Human Rights Code. And it lays out specific, there's a whole big section in regards to renting out and rental housing there that if, it's not like it's the most exciting read, but it gives you a good kind of reading or understanding about what human rights, because that also goes to not only what a landlord can ask or can ask, what they can put into an advertisement when they're advertising for a rental unit, because you can't be specific and say women only, no children, no so-and-so, and you can't, and God forbid you talk about somebody where they're from, like, no Europeans, no, I don't want people from the Middle East, or I don't want people from South America or whatever. I mean, so you got to be really, really careful. So if you're advertising, and that's a lot of times is the first form of asking questions, it's got to be pretty concise and say, 3-bedroom apartment for rent in Central Oshawa, whatever. And then you kind of get a reaction from that. And there's such a high need for rental housing out there anyways. You should get a pretty good response on any sort of ad or that's the kind of the initial thing that you're putting in there. But in regards to the questions when you first speak to them, and if they're hesitant when they answer a question, that's also another gut thing. I mean, if they're like, if they're like, I don't think but you can't say to them on the phone, I'm not going to rent to you. You're not the right person for me. You gotta be like really, on the line and say, if they call you back and, you've rented out to somebody else, or if this is one of the people that, unfortunately, that is not on your top 10 list of people that you're eliminating, you got to be really careful in what you say to them in declining them. Because again, they'll go and put a complaint into the Human Rights Tribunal, and you don't want that.
Right.
And I'm not saying this to scare anybody, because like I said, if you go and read the stuff online, you're going to get better educated and you'll understand a lot better. And I know you have a number of places yourself that you rent out. So over time, you get better at it. You get better at asking the questions. You get better at, what you look and don't look for when you meet them face to face. But
right,
that's kind of
and I guess one of the things as well too, because I mean, obviously, yes, when you respond to them, you want to make sure that you're doing it correctly. So in the past, what I've done is I said, listen, we've decided to continue to keep looking. That's a legitimate response that you can actually say to them. So one of the things, and I'll just circle back to what you were talking about in regards to the pets. So what I used to do when I used to do the screening myself was I would actually put in there, pet friendly. Mm-hmm. So now if they came and this way they would be honest and they would say, yeah, I've got a dog or I've got a cat. And if I didn't want pets, when they call me back, I say, hey, look, I'm going to continue looking. And and that's perfectly legal, correct?
So there's no discrimination. Yeah, that's fine. That's fine. Right. Absolutely. That's because you're not discriminating against them. I mean, if they say I have a pet lion, well, you're not going to have a lion.
Right.
Or snake. Believe me, I've seen, unfortunately, I'm not that I've ever seen lions, but I've seen some like really weird stuff people that have as pets. I mean, I remember one guy that, had like 100 pet mice. And I'm like, oh my God. I had nightmares for like a week after, that encounter with this guy. But if it's a normal like cat and dog, and obviously, there's been a lot of talk in the past number of years in regards to dogs, and because there's some breeds that are not allowed in certain parts of Ontario, etc. Like pit bulls, etc. I mean, pit bulls are fine dogs. I think it's more the people that raise them as opposed to the animals themselves. But again, you got to be really careful. It's just that whole, and I like your approach and what you're saying in regards to pet friendly. I think that's a great idea.
Yeah. And sometimes what I'll even do is, and listen, I have properties where I do have pets in there. But what I'll do as an extra safety precaution is, if I'm going with them, the gut check is good. I will give them a call and say, hey, look, you know what? There's one last piece of information I need to get from you. I'm actually in the area. Do you mind if I just pop by real quick?
Oh,
and what that does now, it allows me to see how they actually really live, right? And I get a chance to potentially meet the dog or the cat, and to see, whether or not they're well groomed as well too. So that helps as well.
That's great. That's amazing. That's very smart.
Yeah. I've been doing it for a while, so I've made a ton of mistakes. Trust me. But listen, I wanted to switch gears a little bit here. And I know that there's been some new rules and regulations that have come down the pipeline. Can you maybe kind of walk us through some of the new stuff that's actually recently come down the pipe?
Okay, so this is called the Fairness Act. Well, that's kind of what the abbreviated version is.
And not fair to the landlords, right?
Absolutely not. I think it's like, I would never use the word crazy. I mean, some of the stuff that, if they put towards the landlord that it'd be more fair to the landlord, that'd be great. But everything is basically geared towards the tenant, which makes it worse for a landlord, if they want to evict somebody. I mean, a legitimate reasons to evict somebody. And it gets tougher and tougher. And unfortunately, that's why a lot of people are getting out of the landlord business, is because they say, it's just not worth it anymore. It is worth it over the long term. And if you're going in for the long term, it's worth it over the long term. But okay, so here are the changes. So the first change that came about was, as of April 20th, 2017. It actually, which was weird, because the change to the law wasn't enacted, I think, until sometime in May, but they made it retroactive to April 20th. I don't know why they picked that date. So what that law is, what is known in the industry as the 1991 rule. So the 1991 rule, or the exemption, was, a landlord is allowed to raise the rent a certain percentage each year, actually after 12 months has passed. And what is that? It's based on the guideline amount set by the government, which is then becomes the landlord and tenant board. If it's 1.8, 1.5, whatever the current amount is. And that's what's set. And there's certain steps you have to do when you do it. You would have to serve what they call an N1 notice, and it's 90 days in advance. And again, it's only once every 365 days. But this 1991 rule that was out there was, if the residential unit or units, like if it's a building, if it was built after 1991, then it's exempted from the act. So basically what that meant was, like in most new housing, and, depending where you are, and most houses, this is Ontario, most houses are actually built after that time, but some are older, from the 60s, 70s, 80s. But if it's in a newer development, it'd be like, oh, great, so I can raise my rent to cover, certain costs, expenditures, etc. And there was no cap to it. So as long as you gave them the 90 days notice, and it would be under an N2, and you don't need to, your listeners don't need to know these forms, it's just I have them in my head, that you could raise it 20% or 30% or 40%, whatever the market would bear, and you could raise the rent. But now, as of April 20th, they took that out. So everybody has to follow the guideline. And It's actually worse for I say most condo owners, because that's where the people were getting hurt the most, was condo owners, because people would buy condos, and until the condo was registered and they have a board of directors, well, they weren't allowed to. They're not supposed to charge condo fees, or and so they'd say, okay, for the first 2 years, there's no condo fees. So if you rent out your condo or condos, you say, okay, what's the market, and this is what it is. So let's say it's $1,500. And then all of a sudden, 2 years later, the condo corporation says, okay, you guys now have to start paying fees, and it's $200. And then the next year it's $500 because there's no cap to that. And how do you get back that money? Well, before, with the 1991 rule, they'd be able to get it back through the increase in rent. And now they can't. So it's very difficult for them. So that's one rule that's gone out. Then there was another thing, and again, this applies more to larger landlords, and I'm talking larger, that one that owns huge buildings. It's called changed to what they called an AGI, or above guideline increase. So that was the same idea. You could apply to the board if you had capital expenditures, like you put in a new roof, you put in elevators, you put in new windows, and it costs $300,000, $400,000, $500,000, $1 million, whatever it might be, and you can actually apply. Besides the guideline increase, you can apply for what they call an above guideline increase, and it's on top of that. That's been restricted too, and I don't really need to get into that one, because it's more, they just changed the rules a little bit on that, and I'm sure it doesn't apply to too many of your listeners.
Right.
The next thing is for landlord's own use. So what would happen is landlords would get frustrated, and there's a form, it's called an N12. And people that are in real estate are familiar with this N12 anyways, because when a property is sold, an N12 is used. You have to serve it to the tenant, as long as they're not on a lease, that they could be served this N12 notice that the new owner or purchaser would want to move into the property, and you have to give at least 60 days in advance. And then you get, the normal process, you should go to the board and get an eviction order in regards to that. And that was pretty straightforward. But what would happen with landlords is, they try to get them out on certain things and it get kicked out of the board. And this would happen. So landlords would say, you know what, I'm just going to move in there myself. And you can also serve an N12 for landlord's own use. So you can say, whether it's, for the landlord's spouse, the landlord's children, the landlord's parents, or a caregiver, that they can move into the unit. And it was relatively easy to get those applications through, because they weren't contested too much, because it's based on good faith. Well, the board found out that a big chunk of these applications, they weren't on good faith, that they were just lying just to get the tenants out, and then the landlord would turn around and re-rent out the unit. So this, for the landlord's own use, there's new restrictions on it. I'm sorry, I'm kind of stuttering there for a second. There's new restrictions on it. Is the fact that, number one, you have to serve it, again, 60 days in advance, at least 60 days in advance. Mm-hmm. And again, they can't be in a lease. It has to be end of term, or they're month-to-month tenant.
Right.
And the landlord, number one, has to move in, and this part of the rule hasn't changed. They have to move in for at least 12 months. But you can't move in there for like 2 months and then turn around and re-rent it out again. Which, to me, that's pretty fair anyways, or if you have a child, that part of it was okay. That hasn't changed. But what has changed is, well, before the termination date on this notice, you have to give the tenant or tenants 1 month of rent. So if your rent is $1,500, so they not only in addition to the 60 days notice, they get an additional $1,500 before they leave. Or
including their last month's deposit as well.
Well, no. The last month's deposit goes to the last month of tenancy, anyways.
Okay, so
it's always applies.
Right.
And that applies. Essentially, they get it back. They would get the last before they leave, they get technically that last month's rent back.
Right.
Right. That's kind of what it is. But there's an exception to that. Like if in some of these circumstances, they have a lot of units. They have to provide alternative housing. Say, okay, you have to move from here, but I have housing that's at the same rent as what you were paying over here. Do you want to? You can offer it to them, but even still, you still have to pay them the month. I mean, if you give them other housing, no, you don't have to do it, but
Right.
you have to pay them a month. Plus, on top of that, it's not like it's bad enough already. The landlord, which I think this part of it is just totally ridiculous, but that's my opinion, right? That the landlord not only can't move back in for 12 months, which I agree with, like I said before, but the landlord cannot sell that property for at least 12 months, which to me is total insanity. And the reason I use the word insanity, and I don't mean that in the human rights point of view, I mean it's insanity. Like, what if a landlord gets into a financial crisis and they need to sell the property? Well, if they do, and the tenant comes back, because the tenant can come back up to 12 months after they've moved out for an application to the Landlord and Tenant Board. Well, if they follow the guidelines exactly, the tenant can come back and let's say the landlord moved back in or sells a property. Well, the tenant can ask for a difference in rent. So let's say the rent is $1,500. Their new rent is $2,000. So they can ask for 500 times 12, which is $6,000. They can ask for all their moving expenses, and the board can and will fine you up to $25,000.
Wow.
Yeah. And the last one that is just coming through of the changes is a standardized lease. This one I actually agree with. And the reason I agree with this one is because there's so many leases out there that are really, really bad. That, you know, a landlord puts all these different things in their lease, or they get a lease online. And I saw it a lot more when I was with Legal Aid. Like, you would see a lease and they go, where the heck is this lease from? Oh yeah, well, I got it online. I Googled lease in Ontario, and then you actually look at the bottom of it. It's from Ontario, California.
Right.
Yeah, it's
and I mean, even though there are all these different crazy leases out there, I mean, at the end of the day, I mean, I can put as many different clauses as I want in there, but it all comes back to the Landlord and Tenant Board Act,
right.
and whatever is in there is what they have to abide by, essentially, correct?
Right, exactly. But it's better if it's on a standardized lease because it lays it out perfectly in the lease itself. So, you know, everybody's expectations are exactly the same.
I agree.
mean, because I've seen some really, really bad leases, and, you know, landlords were trying to enforce like really ridiculous things, and then it goes to the board, and it's, you know, it's a waste of time and energy, and then people get frustrated. And what's the point? If there's a standardized lease that everybody agrees to, and I'm sure once it comes out, and it's the next thing that's going to come out, they haven't given a date yet, but when it comes out, well, so be it.
Right.
I mean, the only thing is with, go ahead, sorry.
Yeah, no, and I agree with that. I think there should be a standardized lease agreement because I think that makes sense, and you don't have people guessing and trying to figure out what they can put in there and can't put in there. And I think it just is a good way just to referee what's going on between the landlords and the tenants, right? So I agree with that. But I also just wanted to kind of switch gears a little bit because I do appreciate that because I know there's a lot of changes that have gone on. So thank you for that. But what about security deposit? Because I know I've been asked that question a few times. Can you take it as security deposit?
No.
Okay.
The only thing you can take is first and last month's rent.
Right.
And the only other deposit you can take is like a key deposit. So like, you know, somebody who has one of these fancy keys into like a building. I'm saying fancy. It's not really fancy, but, or, you know, a lot of them have that little card. They'll have a card and they'll say, okay, it's a $25 deposit. When you leave and you give us back the card, we'll give you back the $25. I mean, you can't charge like $100 key deposit. I mean, it's a reasonable amount. Whatever's out of pocket for the landlord, they can, you know, turn around and charge the tenant for, but it's refundable when they leave. And that's the only other thing. So first and last month's rent. But I mean, in the lease itself, I mean, the whole idea behind the security deposit was when people, or what they used to call security damage deposit, is if there was damage. And then it goes back to what we were talking about earlier in regards to pets, because, you know, pets causing damage, etc. But I found that actually people cause more damage than pets. So, you know, and you're responsible for anybody who, you know, lives or, you know, visits the unit anyways for what they do to the property. So, no, that's so you can't get that.
Okay. And then what about, and I know some landlords have gotten themselves into some sticky water with subletting. Now, can a tenant just sublet a property at any time, or does the landlord have to give permission?
The landlord has to give permission. I mean, it's under the Residential Tenancies Act, I'm pretty sure. It's Section 97.
Right.
And basically what it is that they're allowed to sublet it. I mean, and some people may have it in or out of their lease, but they can't sublet it. But they have to have the consent. What some tenants do, they get somebody in there and they sublet it. And, this landlord comes to visit and they knock on the door and they go, "Who are you?" "Oh, I'm Bob." "And Bob, I'm the tenant." "No, you're not the tenant. I rented it out to Mary." Like, who the heck are you? But the landlord has a comeback on that. Once they find that if there's an illegal subletter, they can, as long as if it's within 60 days of them becoming aware of it, they can, apply to the board to have this person evicted. So, but again, if a tenant is smart, they'll let the landlord know, look, it happens a lot in student housing, in your region. I know in Durham, there's a lot of, student housing, etc. But, it happens in those circumstances, but you should make the landlord aware of it and get their consent. But the landlord can't, refuse everybody, because unfortunately the tenant can turn around and apply to the board and say, he's refused. There's always an alternative for a tenant to turn around to the board and complain about something.
Right.
So you want to make sure as the same way that you vetted out the original tenant, you should try and vet out the subletter. But a subletter, it's basically under the original tenant. So if they do any damage, you can go back after the tenant.
Right.
So. Yeah.
Okay. Here's another question, and this is in regards to keeping the property at a good temperature. Right. Is there a certain temperature you got to keep that property at in the summertime and in the wintertime?
The only one that they specify, it's more wintertime.
Okay.
There's no real specifics as far as summertime. It's around 20 degrees. And the reason I'm saying around 20 degrees, because each city, each municipality, and you can actually go to their website, they'll tell you exactly what it's supposed to be. It's usually it's not 19, but it's usually like 20 or 21. It's in that range. So, they should keep it. And it makes sense. You don't want anybody to freeze to death in a place, and you don't want to, boil to death. You don't want to be like 30 degrees in there because,
right.
Then other tenants are getting complete. But if they're paying the hydro, that's up to them. But if it's up to the landlord, especially in an apartment building, it's got to be at least 20 degrees.
Right. Because I've seen it in some situations where, the tenant comes in and they love to crank the heat because they want to walk around in the wintertime with their shorts on, but they also love fresh air, so they'll keep the windows open.
Yeah, of course, because you're not paying the utility.
Exactly. So I guess in a situation like that, if somebody was abusing it, you can come in there and, lock down the thermostat and then set that temperature to whatever that guideline is.
Mm-hmm. Exactly.
Okay.
Just don't put it below it. You don't want to freeze people out. You're going to get sick and they'll come back after you at the board.
Yeah, which is the last thing that you want.
Exactly.
What about late rent? Because I've obviously gone through that, and I'm sure a lot of other people that are listening have gone through that as well too. Is there a legal amount that you can actually charge for late rent, or can you charge anything at all?
No, you can't charge anything at all. That's kind of going back to one of my favorite expressions is being proactive as opposed to reactive. So being proactive, like if rent is late. And again, not all your listeners will be familiar with the form, but you can go to the Landlord and Tenant website and look up an N4. An N4 is basically, so if the rent is due on the 1st, which I hope most landlords do it on the 1st because I've seen some strange stuff on the 22nd and whatever. 1st is always the best date to have the rent due. That as early as the 2nd, you can serve this N4. It doesn't mean that you're upset at the tenant. It's just kind of covering yourself, because if you let it run late and then they miss 1 month and 2 months, 3 months, the process takes a long time. And I don't mean a long time like years, but in months in regards to once the tenant doesn't pay the rent and they stop paying the rent, and get them evicted, the landlord and tenant board, you're talking minimum at least 3 months to the point of getting evicted, if not 4 or 5 months, depending on the process. So you want to make sure that you're on top of it. So if they are late, I mean, and if it's just the first time, there's a quick reminder. And the N4 is just basically you running a business. I mean, you're running a business, you serve them the form, and the tenant gets upset and say, look, you pay within the 14 days, this form goes away. Otherwise, we have to take it to the next step. And I'm not doing it because I don't like you. I'm doing it because I run it like a business, which is another thing that I always like to talk about. Make sure you run landlording like a business. Don't take it personally. I mean, some things are going to go well, some things aren't going to go well. I mean, I don't say, oh my God, this person is out to get me and I'm going to lose money and then et cetera, et cetera. No, it's a business and run it that way. And
yeah.
That's really important.
And that's a good point. And that was one of the things that I learned in the beginning was, run it like a business. And anytime somebody was late, even if it was that next day, I'd always issue that N4 because a couple different things. One, what it was doing was also building a case just in case, this guy or a girl is going to be late with the rent for the next 6 or 7 months. At least I've got now a stack that I could prove that, they're headache tenants. And number two, what I would do is I wouldn't blame myself. I just blame the process. Like, look, I hate doing this, but I gotta. This is the process. Yeah. Right.
Yeah. And it's true. I mean, because if you don't do certain things, like in regards to maintaining the property, the tenant can come back after you, right? I mean, and you don't want that. So you want to make sure that it's, on both sides.
Yeah.
Right?
You're setting the rules and the guidelines right from day one. And I think that's important. Now, while you're talking about forms, are there 4 or 5 forms that you could just let us know that, every investor should really understand what they are and maybe kind of have it just at their fingertips just in case? Like, I know we talked about the N4. Maybe if there's like 3 or 4 other ones, and maybe also explain the N4 as well too.
Yeah.
One last time.
So the N4 is probably the most popular form that's used by landlords because it's in regards to arrears of rent. So you serve somebody, and I said, the rent is due on the 1st, they don't pay on the 2nd, they're served this N4 form. They get 14 days, and 14 days is based on personal service. Now, I mean personal, like handing it to them, putting it under the door of the rental unit or putting it in the mailbox. And again, it's not one of those mailboxes that's down the street. It's one that's attached to the building. Or it's 19 days if it's mailed. They don't pay in that time frame. As early as the 15th day or the 20th day, you can apply to the board, which is another good form to keep handy, is an L1. And that would be the next step after the N4. Another good form to know about is an N5. And N5 is probably, as far as notices, is the second most popular. I should say popular in a nice way, but it's popular notice that landlords use. What's an N5 used for? An N5 is used, in regards to noise, damages. And again, there's a number of choices on the N5, and it's best to go to the landlord and tenant website, print up these forms, and look at it. And again, if you have any questions, you're more than welcome to call me or any other, professional. I mean, you can call up the landlord and tenant board, but you're going to go around in circles. So it's better that you get it, a right answer from a professional that does this every day. Not that the landlord and tenant board doesn't do it, but it's more geared towards the tenants, fortunately or unfortunately. And so the N5 is used in regards to that. Another one that's used a lot, which is at the end of a tenancy, which is nice to know about, is an N11. That's actually my favorite form of all time. Not that I have favorite forms, but the N11, the great thing about an N11, there's no specifics in regards to the dates. I mean, and if you do have some issues with the tenant and you say, look, I think it's time to move on, and there's a whole big thing out there. It's called cash for keys. If you want the tenancy to end, you don't want to go through the whole process, and you say to and I'm not suggesting it to your listeners to do this, but I'm just saying a lot of people will say, okay, look, I'll pay you a month's rent. You guys leave, we've had some problems, etc., and you sign this N11 form. And an N11 is an agreement to terminate the tenancy, and it could be any date. You can date it tomorrow, you can date it a month from now, 2 months from now. There's no specifics on time period. But it's a good one to have on hand. Not that I'm saying you want to end people's tenancies, but it's a good form to know about. And going back to the N5, and that's the one for noise and damages, etc., and there's certain steps to that, and I don't want to get into all the specifics about it because it gets confusing because there's a void period on an N5, and people are like, what's a void period? Well, if they're good little boys and girls for 7 days, that notice is void and is thrown out. But if it's a second N5, you can actually accelerate to an L2, which is a form that you take to go to the landlord and tenant board. But again, don't memorize this stuff. It's a lot of stuff to digest and all the information I've given you. But, you're more than welcome to, contact me anytime in regards to, lease assistance guidance through the stuff. So, those are probably the most popular ones that are used by landlords. And let me back up. And another good one to have on hand, which is not available on the landlord and tenant website, is an inspection, a notice to enter. Because if you need to go and inspect the unit, there's certain guidelines that you have to follow. You have to give 24 hours written notice, and you have to serve them a notice in regards to that. And this notice is like an intent to enter. And on the intent to enter, that's one form that you can actually serve by not only serving to them personally, but you can actually tape it to the front door of the rental unit so they can read it. You take a picture of it, etc. But on that is pretty specific in regards to why you're going in there. And most landlords don't have any problems in regards to tenants, but it's always good to go and inspect the unit. And I know usual times are, twice a year when you're supposed to specifically change the batteries on the smoke alarm. I know most of them are hardwired in now, but it's good to, go in the unit and just look around and take a look. But on the inspection or the notice to enter the notice to enter paper, you would put on there, the landlord will be taking pictures while they're in the unit. And it's not that you're being nosy, but it's always good to see, is the unit changed any? Is there any damages, visible damages? And just to know about, because you want to, as I said before, be proactive, not reactive and nip it at the bud. Or, if the tenant's afraid to tell you about certain things and you're looking at the ceiling and you see that, looks like there was a leak here, maybe the bathroom's leaking, and they haven't told you. Because the thing is, you don't want it to come back and something that you could have fixed for $50 is not going to cost you $1,000 because the tenant never told you anything about it. You say to the tenant, I noticed this spot in the ceiling. Is there a problem like in the upstairs bathroom? Because I know it's above here. Oh, yeah, it's been leaking, but it's not been really bad. So it's better to find out about things like that, because not every tenant is giving out information as quick as they should in regards to repairs, etc. And it happens after the fact, and like I said, it will cost you a lot more money.
Right.
So it's better to learn.
So let's say you do that, but the tenant refuses to let you in. What can you do at that point in time?
Okay, so if you serve a notice that you're entering the unit, well, you can actually serve them this N5 notice that they didn't allow you in there, and so within 7 days you go back again, and if they don't allow you in again, well, you can accelerate to the landlord and tenant board for the process to have them evicted. But to be honest, and just from my vast experience at the landlord and tenant board, if someone doesn't let them in, and you've got to get to the point that the landlord and tenant board, which is like 6 weeks after the fact, and you go to an adjudicator, and that's the only issue that you have with the tenant, the rent is being paid, etc. on time, are they going to get evicted for that? Highly unlikely. I mean, if they do damage to the property, yeah, they can be evicted, because let's say they've done damage and it's like, $1,500 worth of damage. Well, they have this 7 days in which to pay you or fix it. And if it's not done, well, yeah, you can get evicted on that. But on not allowing access, but again, by serving them the notice, just like the N4 that when I initially talked about it, it gets them on notice and gets the fact that, yeah, this is a good landlord. He's not going to be so easy on me. I mean, initially they may not like it, but they get used to it and they say, look, he's just doing his job. And going back to what you and I were saying, it's a business. And this is the form I have to serve you. So if you don't let me enter the unit, well, I can accelerate it to the landlord and tenant board.
Right.
And you know what? They're going to appreciate that too, because you are being proactive in what you're doing, and you want to make sure that the rental unit is 100%, right? I mean, it's as good for them as it is for you, because they want to live in a place that's, beautiful and comfortable and warm, and to the 20 degrees, and this is where they they live, right? I mean, this is where they raise their families, where they do all sorts of stuff. So they want it to be a great environment to live in. And if you have a landlord that's taking care of the property, well, it's a great relationship to have, which kind of goes back to another thing that I was talking about, that I think communication is probably the most important thing between a landlord and tenant, because once that breaks down, then you're gonna have problems.
Yeah, no, I agree, and I think it's also important to treat your tenants like gold as well too.
Yeah, absolutely.
Because they are there, they're looking after your property, and you want to treat them with respect. And I'm huge on that. But what I want, like I've got, honestly, like as you've been talking, I've been jotting down things. So I've got like 100 questions here, and I can't get through all of them. But okay. And you know what? You've given us just a ton of information. But we are getting near to the end. But I do want to ask this one other question, because we started kind of going down this path, and I think it makes sense. But let's say now the landlord is being a slumlord, and he doesn't maintain the home. Can the tenant just stop paying?
No. They're under the Residential Tenancies Act, which is like, the Bible, the Quran, the Torah of the law. I mean, no, they can't, because it's illegal to withhold rent. And if it goes to the board, it goes to the landlord and tenant board, and the tenant takes you to the board because of, maintenance issues or harassment issues, etc., which I think is disgusting. I totally dislike slumlords. I would never represent a slumlord, and I don't think they should be in the business, because it gives a bad name to people like yourself that are good landlords that take care of their tenants. But they can't withhold rent. The tenants think they can, because they said, "Oh yeah, I spoke to Mary at the landlord and tenant board, or my friend Oscar, withheld rent and it wasn't a problem." Because in front of an adjudicator, you can't get an order for the non-payment of rent, but you can say, look, they now owe me $10,000. I mean, so they can't withhold it. So once they stop paying the rent, even as a slumlord, and I'm not saying there should be slumlords, but they can serve them an N4 notice at the same time. So it's kind of like, tit for tat, which is crazy. So no, I mean, you should always maintain the problem. You should always, maintain the home and take care of it 100%, because, like I said, if you don't take care of it at the beginning, it's just going to cost you a lot more money down the line. I mean, and whether it's rotting foundations or whatever. I mean, I'm not a handy guy, but I mean, I know a lot of stuff can happen in regards to plumbing and electrical, etc. And then, you're not doing it yourself justice. If you think you're kind of saving a few bucks, and well, the tenant doesn't care, he's got a roof over his head. No, it doesn't work that way. You're giving somebody a home. I mean, and I think it's such an important thing, and it's a great thing that you are in the position that you can be a landlord. You have great tenants, and as you were saying, Gary, it's your investment, and they're taking care of it. So, I know I'm going in circles, but they can't withhold the rent. But don't be a slumlord anyways.
Right. That's no. Yeah. And that's good. That's good information to know. Yeah. I can guarantee you, after this call, people are going to probably call me up and say, Gary, who are your property managers? Because I am not doing this on my own. Because there's a lot of things that you have to be aware of, right?
Yeah. So. And going to that point, if you just give me a second, where you said the property manager, you just brought up a good point. I think it's really important, especially in this day and age. I mean, so many people don't even live like anywhere near where their rental properties are. They can live in Toronto, but the rental properties are out in Oshawa or in Barrie or in Orillia, whatever. But no matter where it is, I think just for peace of mind, property managers are so important. Good property managers, and they're worth every penny that you pay them. Because again, it's part of your business. It's part of the investment. It's the same idea. Like if something happens to the unit, that you go instead of having like a handyman, you hire a professional to do it. You get a professional electrician, get a professional plumber. You get these people to fix your units, because if it's not fixed properly or to code, it's going to hurt down the line. So yeah, I think a property manager is really important.
Yep. Now, you know what? Lots more questions I've got, but we've got to the end. So, can you just give the listeners just one final piece of advice that Howard would say? Make sure you do this.
Well, the 3 points that I think proactive, not reactive. Like, get on top of it right away. Communication is the key, and run it like a business. I mean, those are always the 3 things that I drill home that are so important. And you know what? I mean, if you have any questions, don't wait to ask somebody the question. You know, this form looks pretty easy to fill out. I could probably do it. And then you go, if you have a bad circumstance with your tenant, and you get to the landlord and tenant board and you find out that it was filled out wrong, and you got to start from square one. So those, as important as a property manager, as important it is to have, professional electrician, etc. I mean, hire a professional to take care of your legal stuff too. And I'm not saying me specifically, but I'm just saying in general, you should, or at least get some good advice from somebody, because that's worth its weight in gold too. And it helps your overall landlording business.
Right. I agree with that. And yeah, surround yourself with a good team. 100%.
Yeah. Yeah,
so
absolutely.
Howard, listen, thank you very much for your time. Very informative. I learned a lot from this. I know everybody listening will agree. What's the best way for the listeners to get a hold of you if they do want to contact you, or if they do have any other questions, or maybe they're stuck right now with a nasty tenant and they need help?
So the best way to get a hold of me, well, number one is my phone number, which is 705-722-1971. And you can text, call, or you can actually go to my website, and then you can actually not only see what I look like, but learn a little bit more about me and see people's reactions. And it's www.tavroges, TAVROGES, legal, legal.com. And that's the best ways. And I'm very accessible. And like I said, 24/7, even when I'm walking my dog Toby, I answer the phone. That's just the way I am.
Right. And you know what, if they do go there and they take a look at your picture, they will see and understand that, yes, you used to be in the clothing business, because you are, you're dressed very sharply. So
thank you very much.
All right. Listen, Howard, thank you very much again. I appreciate it. And you know what? We'll definitely have to have you come back out again next year and do a talk for a group. So it was great and great having you on the call.
Thanks for having me.
All right, Howard. You take care, and we'll talk soon.
Okay. Thanks.
All right. Bye.
All right.
Thank you all so much for joining this month's podcast. I hope you guys really enjoyed the content. Don't forget to check out smarthomechoice.ca to learn more about real estate investing and how we can help.